3 days ago, the United States Supreme Court issued a ruling that stripped legal status from over 350,000 people who have been living and working in this country legally for years, some of them for decades. And in doing so, the 6 conservative justices did something that goes far beyond immigration policy. They handed the executive branch a power that no court in American history had ever handed a president before: the authority to destroy the lives of legal residents with zero judicial oversight. None. Not a single court in this country can stop it. If you are only now hearing about this, that silence is not an accident. This is the kind of ruling that the institutions designed to inform you quietly hope you will process as a policy dispute, a debate about immigration, about who belongs, about borders and enforcement. That framing is deliberate, because if you understand what this court actually did on June 25th in Mullin versus Doe, you are not thinking about immigration anymore. You are thinking about power, about who has it, about what happens when courts decide that some people, legal residents, people who paid taxes and followed every rule, simply do not get to ask a judge for help. That is what happened. And every American, regardless of where you stand on immigration, deserves to understand every word of it without a filter. If you are watching this channel because you refuse to let the most consequential legal decisions of our time disappear under the noise, subscribe right now, not for the algorithm, for yourself. Because what the Supreme Court did this week has implications that reach far beyond Haiti and Syria and far beyond immigration. This ruling is about the architecture of American power, and it is being buried. Subscribe and let's get into it. To understand what just broke, you have to go back to 1990. Not because history class matters, but because what Congress built in 1990 is exactly what the Supreme Court just dismantled. Congress passed the Temporary Protected Status Law, TPSI, for one reason: the world is unstable. Natural disasters happen, civil wars erupt, governments collapse, and sometimes people from those countries are already living in the United States legally when catastrophe strikes, and sending them home means sending them into a war zone, into rubble, into violence they had nothing to do with and no way to survive. TPS was the answer. A carefully constructed legal program that said, if your home country is too dangerous to return to, you can stay, you can work, you can build a life, not forever, temporarily, until things stabilize, until it is safe to go back. And Congress, understanding that this kind of humanitarian decision required more than one person's judgment, built oversight into the program. The Secretary of Homeland Security had to consult with other agencies, had to review actual country conditions, had to make a documented determination, and if that process was skipped or corrupted or ignored, federal courts could intervene. That oversight mechanism existed for 35 years. Every administration, Democratic and Republican, operated within it. It was not controversial. It was the law. Then came the terminations. In 2025, the Trump administration announced the end of TPS for Haiti, then Syria, then country after country, 13 in total, regardless of conditions on the ground, regardless of the consultations the statute required, regardless of the documentation the law demanded. The rationale, to the extent any was offered, was thin to the point of transparency. A Homeland Security secretary who publicly called Haitian immigrants leeches and foreign invaders. A president who had repeated demonstrably false claims about those same immigrants in front of a national audience. And a termination process that lower federal courts found, twice to see, had likely violated the statute's own requirements. So those courts did what courts exist to do. They paused the terminations. They said, before we let this happen, let's make sure the law was actually followed. Not forever, not a permanent block. A pause, a chance to look at the record and determine whether the executive branch had done what Congress required. The Supreme Court just said that pause was unconstitutional, that no court, not one died, has the authority to review whether the Homeland Security Secretary followed the rules Congress wrote, that the TPS statute's bar on judicial review of any determination is so broad, so total, so absolute, that the people whose lives are directly destroyed by these decisions have nowhere to go. No courtroom, no judge, no appeal, nothing. Let that sit for a moment. Congress wrote a law. Congress built in procedural requirements to constrain executive power, and the Supreme Court just ruled that if the executive ignores those requirements, the people harmed by that violation cannot go to court to enforce them. The law Congress wrote to protect people cannot be enforced by anyone except the executive branch itself. The fox does not just guard the henhouse. The Supreme Court just ruled the fox cannot be audited. The vote was 6-3. Every conservative justice in the majority, every liberal justice in dissent. Justice Samuel Alito wrote the majority opinion, and the language he used, the framework he constructed, deserves to be examined word by word because it tells you something important about where this court is going. Alito's central holding is that the TPS statute's language barring judicial review of any determination related to TPS designations is, in his words, clear and very broad. So broad, the majority concluded, that it strips federal courts of jurisdiction not just over the policy judgment, whether to end TPS nows, but over the procedural question of whether the administration followed the process Congress required before making that judgment. Read that again carefully. The majority is not just saying courts cannot second-guess the president's humanitarian judgment. It is saying courts cannot even check whether the executive branch followed the law Congress wrote to govern that judgment, the procedural requirements Congress put in place, the consultations, the documentation, the review of country conditions, are now, under this ruling, essentially suggestions. Suggestions with no enforcement mechanism. Suggestions that can be ignored without consequence because the people harmed by ignoring them have no legal recourse. There is a more troubling dimension lurking inside the Alito opinion that is not getting nearly enough attention. Justice Thomas joined the majority in full, and he went further. His separate concurrence argued that the Constitution's Fifth Amendment, the one that guarantees due process and, through decades of Supreme Court precedent, equal protection against the federal government, may not even apply to non-citizens in this context. He suggested that Bowling v. Sharp, the 1954 decision that desegregated Washington, D.C. schools and established that the federal government is bound by equal protection principles, was wrongly decided. Sit with that. A sitting Supreme Court justice just put on the record in 2026 that a foundational civil rights precedent from 1954 may have been an error, not in a theoretical law review article, in an official concurrence to a Supreme Court majority opinion. That is not a footnote. That is a signal. Justice Elena Kagan's dissent is one of the most direct, most unsparing documents to come out of this court in years. She did not mince words. She did not soften the landing. Kagan wrote that this ruling effectively tells TPS holders they may simply be put on the next plane. Her argument is straightforward and devastating. Congress created TPS. Congress wrote procedural requirements into the statute. Those requirements exist precisely because Congress did not trust any single executive branch official to make these decisions without accountability. The whole point of the procedural structure was to ensure that when someone's legal status was taken away, it was done through a documented, consultative, legally compliant process, not through the unchecked discretion of whoever happened to be running the Department of Homeland Security at any given moment. The majority's ruling, Kagan argues, does not just gut TPS. It guts the principle that executive power must operate within the boundaries Congress establishes. It tells the executive branch that in this domain, immigration status, removal protection, the legal lives of 1.3 million people from 17 countries, the rules Congress wrote can be broken without consequence because there is no one left with authority to enforce them. Justices Sotomayor and Ketanji Brown Jackson joined Kagan's dissent, and Jackson's questions during oral argument had pointed directly at what was at stake. If the procedural requirements mean nothing, if the consultation the statute demands is just, as Justice Barrett asked during argument, a box-checking exercise, then Congress wasted its time building safeguards into a law that one person can simply ignore. The majority did not have a good answer to that. It had a statutory interpretation argument. It had linguistic analysis. What it did not have was a principled account of why Congress would build procedural protections into a law and then intend those protections to be judicially unenforceable. Now let's talk about what this means in the real world. Not the legal theory, not the constitutional framework, what actually happens to actual people in the next few weeks and months. Start with the numbers. 350,000 people from Haiti and Syria are the immediate targets of this ruling. Their TPS is being terminated. Their work authorization ends. Their protection from removal ends. Some of them have lived in this country for 15 years. Some of them have American citizen children. Some of them own businesses, pay mortgages, coach Little League, serve in community organizations that would collapse without them. Ohio, specifically Springfield and Columbus, is already anticipating enormous impact. Advocates on the ground have noted that affected residents could lose the ability to apply for or renew a driver's license as early as July 6th, not in some abstract future, 9 days from today. But the immediate numbers, as devastating as they are not the full story, because the ruling does not stop at Haiti and Syria. The logic of Mullin versus Doe applies to all 1.3 million people from 17 countries currently holding TPS. The Trump administration has already terminated TPS for 13 of those countries. The legal shield that had protected those terminations from taking effect, the lower court orders that the Supreme Court just overrode, is now gone. Not weakened, gone. The only active TPS designation that has not been terminated is Ukraine. Every other country on the list is now operating under the framework this ruling established. The executive branch can end your status, and you cannot go to court to challenge whether the law was followed when they did it. Think about who these people are. They are not people who snuck across a border. They are not people who overstayed visas or evaded law enforcement. They are people who the United States government invited to stay. People who were told, come into the light, register your status, follow the rules, and we will protect you. That offer was made not by one administration, but by a series of administrations, Democratic and Republican, over decades, and the Supreme Court just ruled that offer can be withdrawn immediately, totally, without judicial review, by the decision of one cabinet secretary. There is a word for what happens when a government invites people to identify themselves, to register their status, to become known to the state, and then uses that registration against them. History has a word for it. And the fact that it is uncomfortable to say that word out loud in the context of American immigration policy does not make it less applicable. The political reaction to this ruling has been exactly what you would expect and exactly as revealing. The White House called it a tremendous win. A spokeswoman said TPS was never intended to be a pathway to permanent status. That statement is technically true and comprehensively dishonest at the same time. TPS was not intended as a pathway to permanent status. It was also not intended as a guarantee of eventual deportation. It was intended to be temporary until conditions in the home country allowed for safe return. The question that statement conspicuously does not answer is, are conditions in Haiti safe for return? Are conditions in Syria safe for return? The answer, documented by the same U.S. government agencies that the TPS statute requires to be consulted, is no. Haiti is controlled by gangs. The Haitian government itself has said it cannot guarantee the safety of returning nationals. Syria just emerged from a decade-long civil war that killed more than 500,000 people. The Trump administration's own Secretary of Homeland Security acknowledged in her termination notices that conditions in these countries remain concerning. And the Supreme Court just ruled that none of that matters legally, that courts cannot review whether the administration actually complied with the statute's requirement to consider those conditions, that the factual record, the documented evidence of ongoing humanitarian crisis, is simply outside the scope of judicial scrutiny when it comes to TPS decisions. Governor Mike DeWine of Ohio, a Republican, said what many establishment Republicans are thinking, but not saying loudly. This is a mistake, not just legally, practically, morally. The people being deported are, in many cases, people whose communities depend on them, people who have been model residents by every metric that matters. DeWine did not call it unconstitutional. He called it wrong. And in a moment when wrong is being institutionalized at the highest level of the judicial system, that distinction matters less than it should. Let's talk about something that the mainstream coverage is almost entirely missing. This ruling is not just about immigration. It is about a doctrine that legal scholars have been watching build for years, and it accelerated dramatically this week. The Trump administration has been systematically testing the boundaries of unreviewable executive power across multiple domains. The argument in Mullin that the statutory language bars judicial review so completely that courts cannot even check procedural compliance due is the same argument being made in other contexts. The termination of federal employees, the dismantling of independent agencies, the firing of officials with statutory protections. In case after case, this administration has argued that courts simply do not have jurisdiction to look at what the executive branch is doing. And in case after case, the Supreme Court has been receptive to that argument, not uniformly, not without exception. But the trend line is unmistakable. The court is drawing a circle around executive power in certain domains and telling the judiciary to stay outside it. The founders were explicit about why this was dangerous, not because they thought executive power was inherently evil, but because they understood that power without accountability produces abuse. Always. Inevitably. Not occasionally. Always. The entire structure of the Constitution, the separation of powers, the judicial review, the checks and balances that every American schoolchild is taught are the genius of the American founding, exists precisely to prevent any single branch from operating beyond the reach of the others. The Supreme Court just handed one branch of government unreviewable authority over the legal lives of 1.3 million people. And the 6 justices who did it apparently do not find that troubling. What happens next is uncertain in the details, but clear in the direction. The terminations for Haiti and Syria are expected to take effect within weeks. USCIS has not yet issued guidance on exactly when existing work authorization documents will expire. Employers are being told to wait for that guidance before taking any action, because acting prematurely creates its own legal risks. The window is narrow and it is closing fast. Advocates and immigration attorneys are scrambling to find alternative pathways for affected individuals. Asylum applications, green card sponsorship through employers, marriage-based petitions. The options are limited, the timelines are brutal, and the legal landscape just became dramatically more hostile to all of them because the other 2 rulings issued the same day on asylum seekers at the border and on lawful permanent residents compounded the damage this one did. In Congress, there is no meaningful movement to codify TPS protections into law in a way that would survive this ruling. The political math does not exist, which means the 1.3 million people currently holding TPS from 17 countries are living under the shadow of a legal framework that now explicitly says their protection can be ended at will, without process, without review, without recourse. There will be further litigation. There are constitutional claims, equal protection arguments, due process arguments that the ruling did not fully resolve. Kagan's dissent flagged those as live issues. Some advocates believe there is still ground to fight on. The question is whether those fights can be won fast enough to matter for people whose clock is running out in days and weeks, not months and years. The Supreme Court can issue a ruling. It cannot make a family safe from deportation to a war zone. It cannot give a child their parent back after removal. It cannot undo the lives that are going to be upended by this decision in the coming weeks. Those consequences are real. They are immediate. And they are irreversible. There is something that needs to be said plainly at the end of this, and it is something that the careful, measured, institutionally cautious coverage of this ruling is not saying. What the Supreme Court did in Mullin versus Doe is not a close legal question dressed up in complex statutory interpretation. It is a choice. 6 justices chose to read the TPS statute in the way that produces the maximum expansion of unreviewable executive power. They could have read it differently. They had precedent, they had tools, they had a record of lower court findings that supported a narrower interpretation. They chose not to use them. And the people who will pay for that choice are not abstractions. They are the 350,000 Haitian and Syrian nationals whose legal status ends in days. They are the hundreds of thousands of others from countries the administration has already terminated, who now know that the judicial safety net they thought existed does not. They are the communities in Ohio, in Florida, in Massachusetts, in Texas, whose social and economic fabric is about to be torn by mass removal of legal residents who have been woven into those communities for years. A constitutional democracy is supposed to protect people from the unchecked power of the state. That protection runs through courts. When courts abdicate that role, when they decide that in a certain domain the state can simply act without review, the Constitution's promise becomes conditional. It applies to some people in some circumstances, but not others. And the people most likely to find themselves outside the protection of that promise are, historically and predictably, the people with the least political power to demand it be restored. 7 justices rewrote the architecture of power last week with the nationwide injunction ruling. 6 justices rewrote the rights of 1.3 million legal residents this week with Mullin, and there are still cases pending: birthright citizenship, federal agency independence, election law, that could continue this rewriting before the term ends. You stayed. You now understand what happened and why it matters beyond the immigration headline. Do something with that understanding. Subscribe so you do not miss what comes next, because this story has not finished landing. Share this with someone who deserves the full picture, not the managed version. And leave a comment. Do you think Congress has any realistic path to protecting TPS holders legislatively? Or is this a fight that ends in the courts? The same courts that just said they cannot help? Let's have the conversation this moment demands. I will see you in the next one.